We are going to transition now into a little bit of tax law. Obviously, this is where we're going to spend the bulk of our time next week as well. Everyone should have a copy of their publication 4012 in the red binder. And so I just want to give you a quick overview. If you've never seen one of these before, this really is your resource guide as you're preparing a tax return. And so it has tabs that will help you walk through who needs to file, how do you determine filing status, what are the various sources of income, and where are they entered in the tax return. But this is your resource. And so after going through the various tax lessons, completing your certification exams, anytime that you're doing a return and you have a question, you don't have to memorize tax law. You don't have to memorize all of these pieces. Some of them I think will be more intuitive for you. And as you get better at this throughout the season and maybe multiple seasons with us, there are going to be things that you'll remember. But this is how you make your decisions when you're entering information into the tax return. And so this is a living document for you. In the same way that you're going to be writing on that intake form, this is where you turn when you have questions. And so I just really want to make sure that you know that this isn't something that you tuck under your chair when you're doing a return, but that this is where you go to figure out these kinds of questions. And so Bob's going to walk you through a little bit more today about filing status and dependence. And that's the first kind of couple tabs, like C and D, I think. Oh, B and C. And then next week we're going to spend a lot more time, but know that this is where we'll be walking through. So Bob, I'll turn it over to you. And we didn't have a chance because you snuck away when we did introductions, but Bob Smith, a familiar face to many of you because he's an accounting instructor here at MSTC. He is our champion. He is our tax law guru, and he helps us run this ship and makes this space available to us. So we're grateful for you being here to help today.
Thank you, Erin, and glad to be here. And like Erin had mentioned, publication 4012, which is right here, it's not only specific to us at the VITA program, in that there'll be some things that are really just germane to VITA and to TCE, which is, as far as the tax law part of things go, is really exactly the same thing. Beyond it being specific to VITA, it's just a great publication. I was in practice for about 25 years. I wish I would have known about this. I mean, this would have been at every one of my tax professionals' desks, because it's just really, it's a lot of very, very useful items in it. I mean, it's got a lot of tax law, but it's also got a lot of really useful tools, and we'll look at a couple of those. All right, I've been tasked with the responsibility of presenting filing status and dependents, and if I remember right, we're going to start with dependent exemptions, just kind of float a little bit better. And as Erin mentioned, what is that, tab C for dependents? So a lot of what I'll be doing is related to tab C, so if you want to get your nose around that part of the publication, that would be a good place for us to start. To be a dependent, we need to have a person, the potential dependent, be either a qualifying child or a qualifying relative. And there's a specific order. We analyze, assess whether they're a qualifying child first. If they're not, then we go to qualifying relative. But qualifying relative is always second place. We want to look for qualifying child first. So if they're a qualifying child, they're a dependent, or at least potentially, and there are a few nuances to all of this stuff that it's hard to make really broad statements about any of it. But by and large, if they're a qualifying child, they're a dependent. If they're not a qualifying child, then we'll look at qualifying relative, and of course, if they're a qualifying relative, then they are a dependent. Let's look at some of the publication 4012 resources first. And let's see, we've got a view here which I wasn't quite expecting. There we go.
You want to have a hard copy.
There we go. Okay, oh, that's helpful. Thank you, Erin.
Yep.
Okay, and so let's start on page, well, I guess it is C1. I've got the page in the PDF here, which is 49 for me. I just wanted to start with a few definitions. So this is really just very preliminary for us. We'll see the term student. We'll see the terms permanently and totally disabled. We'll see custodial parent versus non-custodial, and we'll see foster child, just sort of sprinkled in to this conversation this morning. And so let's define. Student, any part of 5 months that they're a full-time student. Any part. 1 day works. Don't need to be consecutive. You could have someone who's a full-time student, and defined is defined by the institution itself as a full-time student. At least part of 5 months. And so we could have a student who was a student on January 31st, all of February, and then dropped out on March 2nd. Okay, that's 3 months. And then they get home and the parents are unhappy and the parents say, let's try again. So they show up on August 29th and they're a full-time student again, and they're a student for 2 weeks of September, right? And then bail out again, right? Not a very successful academic career, is it? But we found our 5 months. We found a little bit of January, found a little bit of February, a little bit of March, a little bit of August, and a little bit of September. They would meet it. Permanently and totally disabled is a really specific definition. We won't run across a lot of that, okay? But just know that there is a definition for it there. Custodial, non-custodial parent, that can be really important. And in our world, the VITA world, there's a lot of situations where, we don't have that sort of that nuclear family that's established and lasts for 40 years, and then there's a lot of variance in the kind of households that we're dealing with, and so oftentimes we're going to be looking at potential dependents whose parents are not living together, or might be living together and are not married. Okay, and for us, that's we're just trying to figure out the tax law part of it. Well, there's no sort of values that we associate with that. We're just trying to figure out the technical aspects of dependency. There's a big difference between a custodial parent and a non-custodial parent. By and large, the custodial parent is in charge. The custodial parent sort of runs the dependent exemption. And custodial, non-custodial, as it says here, is just simply a matter of who the child was with at night the most during the year. We don't care about legal custody. We don't care about what a court document might say. We're really just asking the question, where did that child sleep? Did they sleep 183 days? And I guess for 2016, of course, it's a leap year, so maybe we'll say 184 days. Did they sleep in your home 184 days? If the answer is yes, we're dealing with the custodial parent. If the answer is no, we're dealing with a non-custodial parent. Okay? And, guys, they're going to try to bring in a lot of unrelated, non-essential information that they're going to consider to be important. For us, it's that simple. Where did the kids sleep? Where did the kids sleep? Okay. And foster child, you'll see that, and just know that we need an authorized agency or we need a court involved. It's not the friend of the high schooler whose son or daughter or a young person came to live with them because maybe things weren't good at home. That's not a foster child in our situation. They may use the term foster child, but with us it's very specific. I'll throw in one more for you guys, and that is the term fiancé. Fiancé means nothing to us. Okay? Fiancé means buddy to us. Okay? There's no legal consequence to the term fiancé. Okay? And I'd also say sometimes we got to be careful about the term husband and wife, because they may have never gotten married, but they sort of present themselves to the world as a married couple. We've got to, whenever we can, cut through that. Now, how do we cut through it? I don't know. I mean, we're not asking for marriage licenses, okay? But if they start talking about husband and wife, and then you just overhear something that makes you think, are these folks married? Ask them, okay? And cut through that clutter, all right? Okay. And a half hour, Aaron, I'll never do it. It's just, I mean, let's not even kid ourselves. Okay, now, specifically about dependents. This is page C3 of publication 4012. And first of all, the top part of that, kind of the header of it, those are general rules. Those are applying to both the qualifying children and the qualifying relative side of things. Okay, the person we want to, who wants to claim a dependent, they can't be eligible to be a dependent themselves. And notice those words. Those words are meaningful to us. Could be claimed, not were claimed. Could be claimed. In other words, they're eligible. If they're eligible to be a dependent themselves, they're out of the dependent game themselves right off the bat. They just can't claim a dependent if they themselves could be a dependent for somebody else. Can't claim a married person who files a joint return unless their income is so low that they're filing that joint return simply to get some withholding back. Can't claim a dependent unless that person U.S. citizen, U.S. resident alien, U.S. national. We're probably not going to see that. That's like Guam, and that gets pretty technical. Or resident of Canada or Mexico. So let's think of a couple examples. We have a Dutch citizen who is in our country long enough to meet the substantial presence test, right? And that would make them a resident alien. That would work, okay? What about a Dutch citizen who is residing in Puerto Rico? Well, Puerto Rico is not a good example. Who's residing in Jamaica, okay? Not a U.S. citizen, we don't find them anywhere on that list. What about a Mexican citizen who is living in Canada, residing in Canada? Well, that meets the list, okay? Because look at the list. U.S. citizen, no. U.S. resident alien, no, they don't live here. U.S. national, no. Or resident of Canada or Mexico, yeah, that's working, okay? Mexican citizenship doesn't do it, but Canadian residency does, okay? So my point here is we don't need to memorize this stuff. My point is just if you run into a situation that's even close to that, and really the chances aren't great, just go to the list and be really sort of technical about it. And we can't claim a person unless that person's qualifying child or qualifying relative. So now we're leaving the general rules and we're getting to the specific ones. Qualifying child. Son, daughter, stepchild, foster child, brother, sister. Okay, that sort of surprises us a bit. Half brother, half sister, step brother, step sister. Okay, maybe we're still a little bit surprised by that. Or a descendant of any of them. So, when we see descendant, we're thinking, oh, grandchildren work. Okay, that's sort of obvious. But let's look at that list a little closer. What about a descendant of your brother? What is that? That's your niece, isn't it? Right? So niece works too. Okay? So, we look at that, and unless we look really close, we don't see how big it is. It's really quite big there. The child's got to be under 19 or under age 24, full-time student as we've defined, right? That 5 months part, and younger than you, okay? Or any age and totally and permanently disabled. So Underage 24 and younger than you. And that and younger than you both works for both being underage 19 and age 24. So, that has a lot to do with brothers and sisters, doesn't it? That younger than you part of it. Child must have lived with you more than half the year. Okay? And, if we be technical, that is more than. It's not at least half a year, it's more than a half year. Look at this one. This one surprises, particularly an old tax timer like me. This one always jumps out at the page at me. Because this wording is not, there's no typos here, guys. The child must not have provided over half of their own support. It is not asking if our taxpayer provided over half the support. It's asking, did the child provide over half their support? Let's say you got a 6-year-old in front of you, Well, that's not obvious, guys. That child might be getting Social Security. And that Social Security is considered them providing their own support. Okay, so even 6-year-olds can fail that test. The child isn't filing a joint return, and if the child meets the rules to be a qualifying child of more than one person, that person must be entitled, and we'll look at that in just a moment. But, what is that? That's grandma in the house, that's mom in the house, and that's baby in the house, all right? Because that baby is qualifying mom, but also qualifying grandma at the same time. And we've got to have rules to sort that out, and we do. We do have those rules. Okay. And in fact, we'll look at it briefly, but then with one of our scenarios, we'll look at it closer. Okay, that's qualifying child. Let's say that we fail one of these. Let's say that the child only lived with them for 5 months. Okay, so we would fail qualifying child, and then what are we going to do? We're going to turn our attention to qualifying relative, aren't we? Okay. The person can't be a qualifying child. Well, okay, yeah, we know, right? We've already gone through those tests. They're not a qualifying child. That's why we ended up at qualifying relative, wasn't it? So for us, that's sort of a slam dunk right there. Okay. Number 2, the person must either be related to you in one of those ways, and there's a table we can look at. What are the permissible relations there? Or they must have lived with them all year, every day of the year, 365 days. So, what are you going to see? You're going to see somebody sit down in front of you, an unmarried person, and they're going to have somebody with them. They're going to have their fiance with them, right? And they basically supported that fiance. And we asked the question, did you guys, who lived in the home? In fact, our intake sheet's going to tell us that there was people in the home. And we're going to see that the fiance, which again is Buddy, right? The Buddy was with them for 11 and a half months. And we're going to look at that. We're going to say the person must either be related to you. No, they're not related. Okay? Or lived with them as a member of a household all year. No, 11 and a half months is not all the year. That fiance is not a dependent. Okay? Even though that person, our taxpayer, may have provided 96% of their support. All right? Now, what does sort of the amateur hour of tax preparation, what do they do with that? Well, their analysis is this. They provided over half their support and therefore they are. No, that's not the way it goes down, guys. The way it goes down is by going check by check by check by check through these rules, okay? And if they survive the rules, they're a dependent. If they fail one of the rules, they're not. That's the end of our discussion, right? We're not sort of, what does it feel like? Does that feel like a dependent? We don't care if it feels like a dependent or not. We're all about the rules, okay? All right. Number 3, that the person's gross income must be less than $4,050, and really that's an exemption amount. $4,050, that's where that number comes from. For us, in this room, or in that room over there, when we get real, or wherever you are within the CAP Services family, gross income to us means income subject to tax, right? Somebody's got $10,000 of Social Security benefits and $200 of interest income. They have $200 of gross income. We ignore the Social Security because it's not taxable, all right? So gross income to us means different than it means to me when I'm teaching financial accounting. Gross income in a tax classroom or a tax office means income that is subject to taxation. Okay? And then look at number 4. Here's where an old timer like me says, oh, no, I'm comfortable with that. Right? Because those are the old rules. Those are the rules that, Reagan administration rules, right? And that is that the person who wants to claim the dependent, they themselves provided over half of the support. That's where that rule comes in, but it only comes in play with qualifying relative. Okay, so there's a difference between qualifying child and qualifying relative. Yeah?
I ran into this with one of my friends as we were talking about taxes and stuff. She had a child that was 5 months old when she went to do her taxes, but they wouldn't let her claim that child.
Yeah, absolutely not. No, I mean, the child could have been born on December 31st at 11:30 at night.
And she still should have been
And
able to claim.
that'd be a whole year.
Okay,
That'd be a whole year.
That's what I
Or,
argued too.
or God forbid, they die on January 1st at 3 in the morning. That's a whole year too. Yeah. Okay. All right. Let's see. Okay. Quickly, and I don't want to make a joke of it. And Aaron, if you would kind of keep an eye on it and gently push me here.
Bob,
It's just
you've
the stuff.
surprised yourself many times.
What's that?
You've surprised yourself many times in class, and all of a sudden, we're not going to get through, but we get through.
Somehow, right? It comes together
Yeah.
somehow, right? So the intervention.
Yeah, I don't know how that happened, but
Guys, we're gonna deal with this one more intensely when we look at an example. But this is when more than one person is qualified, has a qualifying child, and it can be mom and dad who are not married in the same household, right? I mean, they're clearly, they could have lived together for 4 years without being married. They could have 3 kids together. All right. Well, what we would have then is dad has qualifying children arrayed in front of him. Right? And mom does too, but 2 separate tax returns. And we got to decide where those kids are going to land. Could be mom and dad, or it could be grandma and mom and baby in the household, right? And that's where these rules come in. And these rules guide us about who's the one who wins, basically. Okay? Who's the one who wins? And we can save a little bit of time by taking a jump ahead on that one. Okay. So let's go back to my PowerPoint. And let's go there. Okay, here's our scenario. And in a perfect world, I would have printed this out for you guys, but maybe if you could take just kind of a real quick notes, or at least listen real close. We've got Jane, divorced many years, and the ex-husband long gone, not even part of the picture here. Made $56,000 in wages, so Jane has a nice living, single, pays all the costs of the home. And by the way, what are costs of the home, guys? Costs of the home are the rent, maybe mortgage interest, the real estate taxes if they own a home, the insurance on the home, the utilities on the home, and the food consumed within the home. So it's a very specific list. Cost of keeping up a home is very narrow and very specific, and it relates really to what's going on inside of that actual structure, basically. Okay. Jane has a daughter, Brittany, who lived with her all year. Brittany's 24. She's never been married. She is a working person. She has a decent amount of income, $10,500, which, by the way, means she'd have to file a tax return, and she's not disabled. Brittany has a baby who was born in 2014. The baby lived in the home. Since birth, no one else lived in the home. So this is our scenario. Grandma, mom, baby in the home. Jane provided over half the support for both Brittany and Peter. So, grandma is providing support towards mom, and that means that she provided more support than Brittany provided herself. Now, frankly, with these numbers, it's a little bit not the most plausible, because 10,500 means that Jane would have had to kick in 10,501. And that's maybe a little bit unlikely, unless, let's say, Brittany's putting the money in savings. Then we would have a more kind of a realistic scenario here. But nonetheless, let's just go with it, okay? And then they're all U.S. citizens and they've got Social Security numbers, so there's no issues there. Okay, so again, we've got grandma who's making a good living. It's her home. She's paying all the costs of the home, and she's providing over half the support of her daughter and her grandson. The daughter, the mother, is a working person and earns a moderate amount of income, but enough that she's supposed to file a return. And then, of course, baby is, just kind of a healthy, normal situation there. Let's run this scenario. Can Jane claim Brittany? Let's go to page C5 of publication 4012 again. Let's just run it. And this is, we're going to find that this sort of tool within publication 4012 really takes care a lot of our concerns, really is helpful to us. Okay, so I'm going to go to a little different place than we were before, and this is page C5 is where I'm at. So it's pretty much the same information as we ran before, just a few pages down, and it's really specific qualifying child, and then it drifts, and the lower we go to the next page, and then we're at qualifying relative. Can you, in fact, in Jane's case, can you be claimed as a dependent? No, Jane can't be claimed as a dependent. In fact, let me make sure. Yeah, that's right. What we're looking at now, guys, just to kind of go back and make sure we're clear on where we're at here, is that we are trying to determine the question, can Jane claim Brittany? That's what we're doing right at this moment. And we do have to be that kind of focused, okay? We've got to be thinking, our taxpayer, this person here. There may be other people involved. We'll get to them, but one at a time. So right now it's Jane. Can Jane claim her daughter? Can anybody claim Jane as a dependent? No, way too much income. Was Jane married? No. So go to step 4. Was the person a U.S. citizen? In other words, was Brittany a U.S. citizen? Yeah. Was step 5. Was Brittany her daughter? Yes. Was Brittany under age 19? No. Under age 24? No. Totally permanently disabled? No. Okay? If no, this person is not a qualifying child. So qualifying child has failed for Jane looking at Brittany. All right? Then, so go to table 2, dependency exemption for qualifying relatives. So next page. Table 2. So let's see, is Brittany a qualifying relative? Is the person your qualifying child or the qualifying? No. We've already analyzed that. No. So go to step 2. Was the person daughter? Yes. Go to step 3. And what we're doing here, guys, is this test here is let's see. Well, this would be the test that would it's an or. Are they related? Now, of course, Brittany and Jane are related, so no issues there. But if they weren't related, then we would go to step 3 and ask, were they in the household the whole year? Okay, so people can claim completely unrelated people, but they've got to be with them all year for that to happen. Okay, but for us, step 2 is a big old yes, right? Brittany is her daughter, so we're going to go to step 4. Did this person have gross income of less than $4,050? In other words, did Brittany have gross income less than $4,050? No, you can't claim this person as dependent. We're done. Failed. Failed QC, qualifying child. Failed QR, qualifying relative. Okay. Yes.
Is Social Security income included in that $4,050?
Social Security is only considered to be part of gross income if it's taxable.
Okay.
And Social Security will only be taxable if there's a fairly substantial amount of non-Social Security income. But by and large, we would say no, it's not. Yep. Okay, then back to our PowerPoint and kind of proceed along. So, can Jane claim Brittany? No, she can't. Let's run the scenario. Who can claim Peter? Kind of the big question of the hour. We'll refer to table C5. First of all, let's consider Brittany to be our taxpayer. Let's consider the daughter to be our client. And sometimes, right, in a VITA world, we're doing mom's return and then we're going to do daughter's return right after, or maybe at different desks, right? And I'll leave it up to you how much you hear. Because sometimes you're hearing things over there which are making your world a little tougher over here. So let's look at Brittany. So Brittany's looking to her son, Peter, and asking these questions. Can Brittany be claimed as a dependent? We've already answered that. The answer is no. Okay, so Brittany's still in the game here as far as claiming Peter. Was Brittany married? No. Was Brittany a U.S. citizen? In fact, I beg your pardon.
Peter.
Exactly right. No, step 2 is, was Peter married? No. Step 4, was Peter a U.S. citizen? Yes. Step 5, was Peter her son? Yes. Was Peter, step 6, was Peter under age 19? Yes. Did the person live with her, did Peter live with Brittany more than half the year? Yes. We're on a roll, aren't we? Did the person provide more than half of their own support? In other words, did Peter provide over half of his own support? No. And remember, guys, I'll tell you, half the tax preparers in this world would see that Jane provided over half of Peter's support and would not even think about Brittany because they're in an old mindset. Rules that were around for decades, which a few years ago were changed, right? But this question is specific and we are not misreading it. Did Peter provide over half of his own support? Absolutely not. Peter, as far as we know, doesn't have a penny of income to use for support. So we would answer that no and go to step 9. Is the person a qualifying child of any other person? In other words, is Peter a qualifying person of any other person? We'll get to that.
We don't know yet.
Okay. Let's ask the question and answer the question, which is, let's see here. Back to our PowerPoint real quick. And now let's have Jane as our taxpayer and go back to our table. So now Jane. Can Jane be claimed as a dependent? No. Was Peter married? No. Let's see, go to step 4. Was Peter a U.S. citizen? Yes. Was Peter son, daughter, no, or a descendant of any of them? Yes. Grandson. So we've got a big old yes for step 6. Did Peter live with her over half the year? Did Peter live with Jane over half the year? Absolutely, he did. Okay. Did Peter provide over half the support? No. Is the person a qualifying child of any other person? Yes. Right? So what we've got is, as we expected, really, we've got Peter as a qualifying child for both mom and grandma. Let's sort it out. And tiebreaker rules, page 50, my page 52. It'd be one back for you guys. You'd be going to page C4, Charlie 4. All right. So let's sort it out. If the child meets the condition to be a qualifying child of more than one person, only one person can claim and get all of the benefits, right? So they cannot have a discussion like this. You know, Jane says, Brittany, why don't you take the earned income credit and I'll take the dependent exemption. It's a package deal by and large. Now, there can be a little split with that if we're talking about divorced or separated parents, but by and large, it's a package deal. Whoever claims Peter gets the whole enchilada as far as benefits go. Okay, so let's look at what the rules are. If only one of the persons is the child's parent, the child is the qualifying child of the parent. Now, we might think we're done, but we're not. Okay, but that seems pretty definitive, doesn't it? And I really wish they'd have a little bit of a notation after that, because we're still not done. Okay, if the parents file a joint return together, that's not applicable. If the parents don't file joint return together, but both parents claim the child, no, that's not applicable here, because you know, we don't really know anything about Peter's dad, right? He's sort of, as far as we know, he's out of the picture. He's just not, he's just not relevant to this discussion because of their circumstances, right? I mean, not like we're saying dads aren't part of the conversation. We're saying Peter's dad's not part of this conversation because we don't know anything about him, right? He's not part of the life, it seems, not providing support. He's gone. If no parent can claim the child, well, that's not our situation either, because the Brittany can claim the child. Peter is a qualifying child of Brittany. Okay, now here's where we're at. This is why I wanted to keep going. If a parent can claim the child, which is the case, Brittany can claim Peter, but no parent actually does claim the child. The child is treated as the qualifying child of the person who had the highest AGI for the year, but only if that person's AGI, adjusted gross income, is the highest of any of the child's parents who can claim the child. And that is our situation. Jane's income is more than Brittany's. Okay. If the child's parents, well, that really doesn't apply. Let's look at the example. Your daughter, Brittany, meets the conditions, or not, I beg your pardon. Peter meets the conditions to be the qualifying child of both Jane and Brittany. Under the rules above, Brittany is entitled to treat her daughter as a qualifying child for all of the tax benefits. The mother isn't entitled to take any of the benefits unless she has a different qualifying child, and she doesn't. However, if Jane's AGI is higher, Brittany can let her mother treat Peter as Jane's qualifying child. If you do that, then Brittany can't claim. So there's really kind of, Jane seemed out of the picture until right at the end, and then we found something, we said, hey, that works. Okay, so that's one example of how these tiebreaker rules go. Now, usually the tiebreaker rules are just going to tell you who's entitled, and that'll be the end of the story. This one was sort of an option situation for us. Okay, let's go. 5 filing statuses. Single, married filing joint, married filing separate, by the way, and I'll just say it right now. Married filing separate's out of scope. We can't do it. If they're married, they don't qualify for anything else, and they're stuck basically with married filing separate. We need to politely have them pick up their papers and find somebody else to help them with their return. In Wisconsin, with our marital property laws, married filing separate is a very complicated filing status. It's more complicated than we'll take on. So married filing separate in our office here, any of our offices, I should say, is dead on arrival, as far as we're concerned. Okay, head of household and then qualifying widow, and we'll do two qualifying widows a year, maybe less. I don't know, but just you're not going to see much of that. Okay, filing status is often a slam dunk. You don't need me, you don't need a book, you don't need each other, you don't need your education to know that. You've got Ward and June Cleaver sitting in front of you, right? And some of us in the room know what I'm talking about, right? And and they've got the Beav and Wally, right? And it's the nuclear family, right? You don't need me to tell you that's married filing joint. Okay, that's a slam dunk. You've got a 21-year-old who lives by themselves, has no children, and provides no support for anybody else, just simply takes care of their own business. That person's single. You don't need me for that. Okay, it's really the kind of the stuff that falls in the cracks that are in between that we need each other, we need our textbooks, we need our knowledge to get us through that. Okay. Let's take a quick peek at some things from Publication 17. This is just really, I was looking at Pub 17 this morning, and they were things that I thought, maybe had some value to our discussion. I won't take much time with it. It's really just sort of me randomly finding parts of Publication 17 that I thought had some relevance. And by the way, Publication 17 is a fantastic resource. Publication 4012 is great. Publication 17 really is kind of the big dog in the room as far as tax reference. Don't go through the tax season without referencing Pub 17. If you do a bunch of returns and you never look at Pub 17 and it's April 17th, I'd ask you to look at yourself in the mirror and say, did I really do the best I could?
I was just going to say, so Pub 4012 is your first line of defense. But as Bob will undoubtedly show us through these examples, and then there will be others, this is where it gets into more detail. We don't provide a copy to every taxpayer or preparer, but we'll have at least 5 at every site so that you can be using that as a reference when you need to get into more detail.
Awesome. Okay, now, what I did here, guys, I went and got Pub 17. I got an HTML copy of it. I just copied it, and then I pasted it into Word. But this is exact wording from Pub 17. Unmarried person, what does that mean? Unmarried or legally separated under a divorce or separate maintenance decree. State law governs whether they're married or not. And sometimes we have to ask them if they're married. Sometimes, they may be going through legal processes. Well, legal separation, we really don't see much of that. You might think, well, I'm separated. Well, that's not necessarily a legal separation. Legal separation means you've got a document in your hand that pretty much says you are separate from that person, okay? That doesn't mean they're going through the process of a divorce, all right? So again, and really we have to rely on them to say whether they're married or not. What do we know about family law, right? Probably not much at all. I know I wouldn't know much about it. Divorced, by the last day of the year, you're considered unmarried the whole year, kind of similar to what we were talking about with the baby who was born late in the year, kind of the same situation. Who's married? Married and living together. Living together in a common law marriage. Now, Wisconsin has no common law marriage. That might be another thing that people are trying to drag you into, right? This is my common law wife here, right? Or what would they say? This is my common law old lady, right? That's what they'd say, right? But Wisconsin doesn't have it. Now, some states do. South Carolina, I think, does. And if they become married under common law in South Carolina and then move here, that comes with them. So we can have common law marriages sitting in front of us. Chances are really small. If they've lived together in Plover for a couple of years, that is not a common law marriage. Okay, we just don't have that provision in state law. Married and living apart but not legally separated, well, sure, they're married. They don't have to live together. They're married. Separated under a what's called interlocutory, not final. And sometimes, maybe not as much. This might have been 30, 40 years ago more. And I don't mean to paint too broad a brush, and I'm not a theological guy, but I did grow up Catholic, and I realized that Catholic, it's tough sometimes, divorce for some religions, Catholic, I think, being one of them. Sometimes you would have saw people who didn't get divorced because they couldn't by their religious beliefs, but in fact they were two separate entities, right, legally, and that's what some of this kind of decree of separate maintenance and those kind of situations. We don't see that much. Same-sex marriage, if they're married, if same-sex couples are married, they are married for for federal tax purposes. Okay. Now, note this though. Registered domestic partnership, civil union, etc., that is not marriage. Okay, so we've got to maybe be a little bit careful on that one. Single. Filing status single if you're unmarried and you don't qualify for anything better. That's basically who single filers are, right? An unmarried person who can't be head of household or qualifying widow. They sort of default to single, okay, because there's no better deal out there for them. Married filing joint, as long as they're married and they want to file together, they can file married filing joint. Again, we don't care if they're living together or any of that. They're married people, they want to file together, file them, married filing joint. Okay, now why would someone not want to file married filing joint? Because really married filing separate is the pitch of filing statuses. There's a whole lot of reasons why we don't like married filing separate, the least of which almost in a sense is that we can't do the return. It's just a crummy filing status. Okay, but why wouldn't you want to file jointly? Well, you don't want to be responsible for your dishonest spouse, who you know is cheating on the tax return, and you don't want to be any part of it, okay? Because if you file joint, when you sign that, you're signing on to the whole thing, okay? Now, there are some ways to extricate someone from that, okay? So it's not like absolute, but by and large, you file a joint return, you're taking on every bit of the responsibility, joint and several, which means that even though it was their income, you could be responsible for every penny of tax on that tax return. Okay, it's not like you got to have it split. That's not the way it works. So it's a responsibility. It's a kind of a burden almost. Married filing separate. In married filing separate, there's a whole list, and that look at how long that list is of reasons why married filing separate's not a very good filing status. But again, for us, we can't do the return. Head of household. Unmarried or considered unmarried, paid more than half the cost of keeping up the home, had a qualifying person with you. Now, this is what I wanted to get to, and I'm rushing here, and I know I need to, and I do apologize. I didn't. It always goes long. Considered unmarried. These are married people, but we, for tax purposes, and only tax purposes. We're not this isn't a divorce court, right? This is considered unmarried. They're filing separate. Our person paid over half the cost of keeping up a home. The spouse was not there the last 6 months of the year, meaning July 1st through December 31st, they were out of the house. If they reconcile for 2 weeks in August, that's going to ruin it for them. Last 6 months of the year, they're out of the house. The home was the home of a child who they can claim as a dependent. That would be a person who is married but unmarried for tax purposes, called an abandoned spouse too. You may see that terminology too, an abandoned spouse. Okay, and then keeping up a home, again, very specific list of items that are considered the cost of keeping up a home. Okay, and I think that's all I've got from that. All right. Okay. I'll tell you what, just for time purposes, let's run one scenario because I just want to get kind of our nose into TaxSlayer quick. Let's run Brittany as a scenario. And the TaxSlayer is awesome as far as this goes. So let's run Brittany through the TaxSlayer. And I'm just going to grab a return I've been playing around with in here, and I'm going to go to, I think basic information is where I want to be. Yeah, filing status. So now this is a different return, but I'm just using the filing status wizard here. And so it's just a wizard. It's not really specific to a return. Was Brittany considered married? No. Was Brittany a U.S. citizen? Yes. Has Brittany ever been married? No. Did Brittany pay more than half the cost of keeping up the home where she lived? No. She doesn't have a qualifying person. So she's not going to be head of household because of anybody living with her. We know that much so far. Continue. Did she pay over half the cost of keeping up a home for a parent? Parents don't have to live with the taxpayer to qualify that person to be head of household. Very kind of not, we wouldn't see it much, but normally head of household means the people you're living with. Well, with parents, I could be keeping up my parents' home, and if I'm an unmarried person, that could still make me head of household, but that's not going to be the case. Did you pay over the half? No, Brittany didn't do that. Based on our answers, Brittany's single. Okay, Brittany's single. And, you know, to some degree, we knew that early on because we knew that Brittany wasn't paying over half the cost of keeping up the home. She's not the head of the household. And so we knew that Brittany was going to fail. So I think that's about all I want to do, and time is precious here. So thank you, guys.